All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We're here this morning for oral argument in our case number TX150001, Sun Devil Power Holdings versus the Arizona Department of Revenue in Maricopa County. These proceedings are being audio and video recorded, so we'd ask that you identify yourself and your client when you approach the podium. Each side will have 20 minutes for argument. Appellant's counsel is responsible for reserving whatever time you may wish for rebuttal. We've read the briefs and we have conferenced this matter, and we look forward to your argument. And with that, you may begin.
May it please the Court, my name is Kenneth J. Love. I'm an attorney with the Arizona Attorney General's Office, and I represent the Arizona Department of Revenue and Maricopa County in this matter. The matter pertains to the valuation of an electric generation facility that's located in Gila Bend, Arizona. The valuation for property tax purposes of electric generation facilities is governed by ARS Section 4214156. The statute breaks the components of a facility into three parts. That would be land, real property improvements, and personal property. Real property improvements are specifically defined, and personal property is everything but land and real property improvements, which covers a very wide gamut of items within an electric generation facility. Most prominently, that would be the generator and the generator housings, so that would be regarded as personal property. We've included a three-level chart at pages 16 and 17 of our brief that lays out the scheme for the valuation, but I'll go over it in a very summary manner right now.
Counsel, before you get there, can we talk very briefly about the motion to amend the complaint?
Well,
we will discuss that. Rather than asking you, I'd like to address something.
Well,
here.
I do appreciate that, but and I failed to mention that I would like to reserve 5 minutes of rebuttal at the conclusion, and secondly, that with me today is Peter Muthing, who has briefed that portion of the aspect of the appeal on behalf of the appellants, and whom I intended to have present with respect to the motion to amend. If the court will allow for
You're
same.
dividing time?
That would be our preference. Yes, Your Honor.
Okay.
And my apologies for moving into things without that bit of housekeeping. If going back to where I was, the discussion needs to center on the fact that land is the cost to the current owner as of December 31st of the preceding calendar year. But then we start getting into the part that is the area of contention. Real property improvements is the cost, or at least the valuation is the cost multiplied by tables the department adopts, and these include percent good factors for each vintage year of the property. That's covered by 14156A2. Personal property valuation is the cost multiplied again by valuation factors in tables that the department adopts, 14156A3. Now,
we don't care. For the purpose of this argument, we don't care about the land, we don't care about the personal property. We're only talking about the real property improvements, right?
Your Honor, I would agree that land is a relatively is an uncontested issue. What is contested are the real property improvements and the personal property, with the question being what is cost? How is cost defined? Because cost is multiplied in the instance of both the real property improvements and the personal property in order to come up with values that are summed, that are created, multiplied values that are then multiplied, added, and create value.
Can I ask a question?
Certainly.
Assume Gila River constructed the plant, the facility, and had all of the information about the cost of construction. You don't disagree that Sun Devil would be entitled to Gila River's cost of construction for purposes of defining cost?
I think if they obtained and possession, and that's not a word that should be dealt with lightly. It says possess the cost information.
Okay, but I'm assuming they have, and Gila River builds the facility.
Yes.
And they possess and have that information.
Gila River possesses it, okay.
And so you would agree then that Sun Devil is entitled to keep that same, use that same value?
Only if, after acquisition, Sun Devil possesses the cost information.
But I'm assuming they have that cost information. That's why I guess the question for me is why isn't, if I understand Gila River didn't build the facility, but their cost is defined by their arm's length transaction in acquiring it out of bankruptcy, and Sun Devil has that cost information. So why aren't they entitled to just have that be the value under the statute?
Because very simply, I think that there are two principal problems with that, Your Honor. Number one, it does not say the seller's cost information. You will not find that in the provision that says if after sale to another taxpayer, the succeeding taxpayer has possession of the seller's cost information.
Well, except it does say, well, first of all, the language is, if after acquisition the buyer has possession of the cost information.
That's correct.
Okay. The valuation of the facility shall continue based on the seller's cost, as if there were no change in ownership except for the land. So if it wasn't the seller's cost information, whose cost information would it be?
It would be the cost of the party first putting the property into service, Your Honor.
Where do you get that from?
Well, I get that from a number of factors, Your Honor, if you will. I think that it's easy to get to that point by virtue of what the definition of cost is, for instance, for personal property. What does it say for personal property? It says personal property is the invoice cost, the cost of transportation, the cost of labor to install, and any transaction privilege tax paid. Well, in the instance of personal property, which constitutes the bulk of the valuation of this type of property, those factors very clearly speak to the origination, installation, transaction privilege tax. So those very much define cost within a lens, and that's the way I refer to it, of origination.
So if you're saying is, let's assume that the original person who constructed it is gone.
Correct.
They sell it to Gila River. Gila River sells it to somebody else. Somebody else sells it to someone else. Someone else finally sells it to Sun Devil. You're saying that Sun Devil has to have the original builder's actual costs on the personal property.
Correct, Your Honor.
And what do you deal then? How do you then deal with the statement in the language in D1 that says the buyer has possession of the cost information. If the buyer has possession of the cost information, the valuation of the facility shall continue based on the seller's cost.
That
Why
would be.
they use the word seller's cost if it wasn't the seller to the buyer?
Because it's this, well, it's dependent upon what the definition of cost is.
Why doesn't that definition just come from 6A? Why doesn't it come from there when it says cost means the cost of constructing or acquiring the property?
Because the specific in that case overrules the general, and we have the specific being the cost being X, Y, and Z, all of which are temporal. All of which have a bearing in the origination.
You just lost me.
Well, it goes back to my statement that says that cost is defined for personal property as the cost, the invoice cost, the cost of transportation, the cost of labor to install, and any transaction privilege tax
The real
paid.
estate improvements, the real property improvements. The cost isn't defined anywhere in the statute as far as the real estate property improvements.
I think that it can be inferred that that can either be the cost to construct or the cost to acquire, given the nature of those type of improvements, some of which are lakes, ponds, treatment plants, treatment ponds.
We know what real property improvements are because subsection B of the statute defines it.
Correct.
So are you saying then that, okay, the land we know, land's not in dispute. Personal property, Sun Devil has to have the original costs of personal property as defined by 6B.
B.
And that as far as the real estate improvements, you fall under 6A, which means acquiring either the construction costs or the acquisition costs.
Which I think would be subject to whether or not the purchaser acquired the cost information as part of the transaction or not. If it did not, then it falls to the valuation as if it owned originally.
So we were saying that
Or, I'm sorry, it falls to the cost in the arm's length transaction that in which it acquires it. Pardon my confusion, Your Honor.
So, just to clarify, the cost information that is lacking in the state's view is the cost of personal property.
I regard it as, excuse me, Judge Howe, I regard it as all of the cost information, but I think that focusing on the cost of personal property is very important to determine what cost is in the context of this statute.
I mean, I assume they would have the cost of the real property improvement under 6A. Are you saying that that's lacking as well?
Yes, Your Honor.
And that's because you're saying that they have to have the original cost?
Yes, Your Honor. And let me address that for a second in a historical context.
Well, wait. Now I'm confused. Are we acquiring the property in an arm's length transaction is not what Sun Devil paid Gila River?
Sun Devil does not want to be valued in terms of the arm's length transaction in which they acquired the property from Gila River.
Isn't the cost, right, I understand that.
Yeah.
Sorry, I didn't interrupt.
No,
but why isn't, my confusion comes from, why isn't their cost information the cost that Gila River paid into bankruptcy?
Well, first of all, it doesn't say the seller's cost. Number one, it says cost information. Now, and I don't think that omission is necessarily something that can be taken lightly.
You're saying that we should read D1 as saying, if after the acquisition the buyer has possession of the seller's cost information, the valuation of the facility shall continue based on the seller's cost. You want us to insert the word seller before cost.
No, I don't want you to insert the word seller. I think that that's entirely inappropriate, Your Honor.
You're saying it shouldn't be.
It should not be. And
you should ignore the second one, which says seller's cost. You want us to ignore that.
That's correct.
Okay.
And let's talk about that in the context of the valuation of these facilities. Prior to the turn of the century, and I know that I'm giving a history lesson here, and perhaps
sorry.
the 21st century, this century.
This century, okay.
All of electric power was generated by utility-owned electric generation plants. It's only at the advent or at the turn of the 21st century that we began recognizing the institution now that is called the merchant electric plant. That came about owing to the fact that there was a perceived change toward deregulation of the electric markets. That didn't come to pass. But the traditional means by which the department valued electric generation plants was that they were put on the books. They remained there forever. They weren't subject to transaction. A utility company bought them, held them, included them in rate base, and the original costs were always there. This marks a change. This marks an opportunity for buyers and sellers of these plants to take part in a market for power and in a market for these such plants. The department had to do valuations in both contexts, both the context of the incumbent electrics and the other context.
So
I see I'm running out of time.
Yes, you are.
And I'd like to cede part of this argument to the question of the motion to dismiss unless there are other pressing questions.
Good morning. Peter Muthig for the Maricopa County, and I'll be arguing predominantly the Rule 15 relation back question. Judge Kessler, you had a question.
I have a question. I actually got two questions. Okay. First question is, the motion to dismiss only applies to the 2013 case, right?
Correct.
So if we were to agree with the court, the tax court, on the issue of the statutory interpretation, but disagree on the motion to dismiss, we would only be reversing the 2013 case.
That's correct.
Is that right?
Yes.
2014, 2015 doesn't apply?
No.
Okay. Second question is, what's your best case that this unity of interest doctrine only applies to the notice provision of 15C? Because let me explain where I'm coming from. As I understand it, the court denied the motion because it found a unity of interest. So it never had to, quote, reach the mistake issue.
Correct.
Or the estoppel issue. If we view the mistake issue, if we view the unity of interest as only applying to the notice provisions of 15C, the notice and prejudice issues of 15C, then the Sun Devil still has to overcome the mistake, still has to show that there was a mistake in fact.
Correct.
So what I'm asking is, I see it as sort of the trial court said, unity of interest trumps everything. Okay. The entire 15C. If you have a unity of interest, we don't worry about mistake. What's your best case to say, no, unity of interest only applies to the, doesn't apply to the mistake element?
Okay, the mistake element is actually, it's independent in our view of the prejudice element and of the notice element.
Right.
If you don't satisfy the mistake, and I guess the best way of looking at it is just to look at the Timon, where they say not every omission of a defendant is a mistake cognizable, okay? So if it's not, if counsel made a mistake in the reading of the law, that has nothing to do with the unity of interest with whatever party was already in the case.
But is there one case that do you think is really clear on this? That says, no, you don't get to unity of interest unless you show there was a mistake of fact.
Honestly, Your Honor, I hadn't seen that issue, and I hadn't been considering it from that perspective because I always looked at it from an independent perspective.
Right. First, you've got to show a mistake, and
Correct.
Then if you show a mistake, you've got to show you've got to meet the other requirements of 15C.
Does the rule in 15C break it out and break the elements out?
It does break it down, and in other words, you've got a notice requirement, a prejudice requirement, and the mistake requirement. And the mistake has to be concerning the identity of the proper party.
So it's your best case would be the rule itself then?
Correct. Yeah, and what we're saying is, and again, I can refer the court, and I'm sure you've seen it, paragraph 21 of the Timon decision is very concise. It lays everything out perfectly, and here, Sun Devil and his counsel, they were aware of the identity of the county. They knew the county could be served as a potential defendant. And so when you take that out of the argument, then you don't have the sort of mistake of identity that Rule 15C asks for.
They made a mistake in deciding that the county didn't need to be a part of the original suit.
That's correct. As they call it, an erroneous omission of a party, not a mistake.
Well, but it's not a mistake in identity.
Correct. That's it. I'll leave the remaining time so that my colleague can have a rebuttal.
May it please the court. Good morning. Brian McQuaid, Squire Patton Boggs, on behalf of Sun Devil Power, with me and my colleague Karen Holman. I don't want to belabor the statutory interpretation issue if you prefer that I get directly to Rule 15C. I had intended to cover the interpretation of the statute first, but based upon...
I would think that the statutory interpretation would be a more important issue.
I agree that the statutory interpretation issue, that if we prevail on the statutory interpretation issue, there is no issue with respect to 15C with respect to the 2014-15 tax years, but there is with respect to the 2013 tax year. As what I would say with respect to the statutory interpretation issue is that the department in its own opening brief at page 18 reads the statute the same way that Judge Kessler did. And that is, at page 18 of its brief, it inserts the word sellers. At page 18, it says, Section 42141516 provides that if the buyer possesses the seller's cost information, the facility will continue to be valued based upon the seller's cost as though there had been no change in ownership. The seller here is Gila River Power. And it's important to keep in mind that there are two transactions that we're looking at when we go to apply Subpart D. Subpart D of the statute is the part of the statute that says in the case of a facility that is acquired from another taxpayer. You had Gila River in 2005 acquiring the property from another taxpayer in the context of a bankruptcy court proceeding. It did not possess the original construction information. There was no acquisition for it to rely upon. When it did not have the original construction cost information, it had to rely upon Subpart D2. That is, the cost it paid as the buyer was its cost. Going forward, now you have a transaction in 2010, 2011, where Sun Devil is the purchaser. And you still look to subsection D. When you look at Sun Devil's transaction and you look at Subpart D1, if after the acquisition, the buyer, Sun Devil, has possession of the cost information, the valuation of the facility shall continue based upon the seller's cost as if there was no change of ownership. We agree with the statement that the Department of Revenue is trying to back away from, and that is that you have to read that cost information is the seller's cost. It's used later in the very same sentence, and if you look at the legislative history, it talks about using the current cost. It doesn't talk about the word original cost, doesn't talk about construction cost. And in this case, if you use the seller's cost, you are using an acquisition price. You are using the 2005 acquisition price, which the lower court found was an arm's length transaction, and which it was undisputed and not raised below that Gila River's book cost accurately reflected that acquisition cost. There is no question that Sun Devil possessed that acquisition cost information. That is what the acquisition price was in 2005, how it was broken across the various assets, and importantly, that with respect to Subpart 6B, when you talk about the cost of personal property, you have to consider that these are not stagnant facilities. So you have the facility that's acquired in 2005, and you have property that's being added in. You have property that's retired, property that subsequently comes into use, for that property, you cannot rely upon a 2005 acquisition price. You have to have the seller's cost information. That cost information for that personal property that's being added in is the invoice cost and whatever that you need as required by statute to determine that cost for that seller. There is no question. If you look at the amended judgment, which I think is in our appendix at the second amended judgment at 132, that the amended judgment goes through that invoice cost for all that property was there. The parties were able to go through each of the invoice costs for all of that property using the book cost and arrive at a value. There's no contention that what we claim is in fact the seller's cost, the 2005 acquisition cost and the cost of putting property in service after 2005 was in Sun Devil's possession and was used to actually arrive at the value that is reflected in the second amended judgment.
But it's based solely on the bankruptcy, the price paid by Gila River in acquiring the property out of bankruptcy, right?
Not solely. There was property that was put into service after 2005 for which we possessed the invoice cost of transportation, TPT tax. Okay. But for the assets that were acquired that were there in 2005, absolutely, Sun Devil had how that book cost, how that cost was broken out amongst the various assets. And there was no argument in the lower court that that book cost did not accurately reflect the acquisition cost. No argument whatsoever. That is, if you needed an evidentiary site for that, it is at the index record 54, Exhibit 2. Gila River's CFO provided an affidavit which we used to support that position, which was uncontested. So to sum up, with respect to the interpretation of the statute, you have to read 6A as providing either construction costs or the cost of acquisition. In this case, there was no construction cost for the 2005 assets. Gila River didn't possess it, so Sun Devil cannot. Instead, Gila River relied upon its acquisition cost. That is the seller's cost, and that's what we relied upon Sun Devil for the assets that were acquired in the 2005 transaction, and then for the assets acquired after that, we had the actual cost information. Turning to Rule 15C, I guess first I want to address the question that you posed, Judge Kessler, to the county's counsel, and that is there any case that stands for the proposition that the notice can satisfy both the such notice as would prevent prejudice and the second prong, I think, knowledge of mistake as to the identity of a proper party.
Do you mean the unity of interest, whether the unity of interest can satisfy both?
Yeah, I think yes. I do believe that a case stands for that proposition, and that is Pargman. Pargman repeatedly refers to the phrase notice and knowledge. Knowledge is the second prong of that Rule 15C analysis. Rule 15C says knew or should have known. So the knowledge that is being referred to in Pargman, we would submit is that Rule 15C subpart 2, knew or should have known that for a mistake concerning the identity of the proper party, the action would have been brought against the party. And so with respect to the notice and knowledge elements, Pargman repeatedly refers to notice and knowledge, notice and knowledge. With respect to mistake, I want to cover the facts briefly.
But does mistake, so are you saying mistake doesn't matter?
No, I think mistake.
Unity of interest trumps mistake?
I don't think unity of interest trumps mistake.
Okay.
But what unity of interest stands for is that when you have factually the close relationship that Judge Fink found, that when you have the Department of Revenue acting for the county in the valuation, that the county doesn't participate in the valuation, it doesn't participate at the State Board of Equalization proceedings, it doesn't get notice or service of the State Board of Equalization proceedings, and it's only when that State Board of Equalization proceeding is appealed to the Superior Court that the county has to have notice. But even then, and that is notice and be named in a lawsuit. And We do not dispute that ARS 42-16-208 requires that the county be named. The case law, it makes clear that the county is an indispensable party. But what you have here is that you have the Department of Revenue receiving notice. The Department of Revenue is the entity that did the evaluation. The Attorney General's office appears on behalf of the Department of Revenue, and the Department of Revenue starts its defense. The defense that it starts to pursue is, frankly, this Rule 15C argument. I mean, if you look at the county's opening brief, it says, upon reading the prayer for relief, the mistake of law concerning the identity of Maricopa County, or I forget the phrase they use, but they talk about the mistake of law, was evident from the prayer for relief itself. It's also evident from the Department of Revenue and its attorney's actions. The Department of Revenue waited. It didn't answer on time. It sought extension. It sought extensions of Rule 26.1 obligations.
We bought that argument. How does that affect that the county also then made a motion to dismiss? They didn't do anything wrong, assuming the state did something wrong. I'm assuming for purposes of argument, the state delayed until the time had run. Why is the county tarred with that? The county didn't do anything. As soon as the county was added, his motion to dismiss was denied, or maybe before, the county came in and separately moved to dismiss, saying it hadn't been, under 15C, it shouldn't have been named, right?
That's correct. I mean, it's correct that the county did nothing wrong, but that's not what Rule 15C asks you to look at. Rule 15C asks you to look at prejudice.
Well, but, counsel, do you agree that the elements, so to speak, in 15C are independent, that you have to show notice, you have to, and then beyond that, you have to show new or should know but for a mistake concerning the identity of the proper party that would have been brought against that party. Those are separate elements.
Absolutely.
And they don't bleed over into each other.
I disagree. I do believe that they bleed over into each other.
I mean, I take your point, and I understand that's your argument, but I don't see how, by the language of the rule, that they do bleed over.
Well, when you have the knew or should have known standard,
Yes.
when you impute notice, the notice that you have to look at the party that had notice.
Yeah.
And so when you're satisfying that, the first part of that second prong, which is the knew or should have known, that I think Pargman very clearly says that the unity of interest, identity of interest can satisfy both prongs.
But then you end up with, but for a mistake concerning the identity of the proper party. And there is no mistake in the identity of the proper party. As I understand the record, and correct me if I misunderstand it, you made a decision that the county didn't need to be sued yet, and that's why you didn't bring the original suit against the county. And there's a mistake, I take it, but it's not a mistake in the identity of the proper party.
I would submit that it is, Your Honor, and I would submit that it is because what O'Keefe and what Timon and what the cases interpreting mistake provide is that you look from the perspective of the party to be added. And that's why you have the knowledge element at the first part of 15C2. And here you have a statute that there is no discretion. There is absolutely no discretion for Sun Devil's attorney to name the county. It had to be named. There is, in fact, a proper party. That proper party was not part of this lawsuit. If you assume that the county knew, and we get to the identity of interest, we get to that imputed knowledge, that if you have the imputed knowledge of that there was in fact such notice because DOR had notice, and that it knew there was a mistake, which DOR seems to concede in saying that once we look at the prayer for relief, we know there's a mistake.
Well, but it's not, I mean, the rule doesn't require this simple showing of a mistake. It has to be a mistake in the identity of the proper party. And I guess that's what I'm getting hung up on, is because I understand that Sandoval made, in general, a mistake, but it didn't make a mistake in the identity of the proper party.
But what I would submit, Your Honor, is that's true in all of the cases which led to the adoption of Rule 15C. The Rule 15C is adopted because we want to have a trial on the merits, not these technicalities, not an attorney who lies in the weeds on 12b-7, who gets extensions, who doesn't put us on notice. And it's clear from Mr. Santos's affidavit that had he been put on notice that the county needed to be a party, he would have immediately added it. But they foreclosed that opportunity. But the cases that led to the adoption of 15C are cases in which there's a statute. The Social Security cases, the cases where there's a government entity that needs to be identified. And in those cases, there are a statute. And the proper party is not named, whether it be the United States of America, the director of a department. The statute identifies who needs to be named.
So 15C really doesn't mean what it says. It just means as long as there's a mistake in suing the proper party, then 15C applies. Is that your argument?
That's exactly my argument. And I think that
even though that's not, so we read out of the rule the identity of the proper party. Then.
I don't know that the identity of the proper, I mean, we're parsing every single word and
but aren't we doing that on the statutory side of this argument also?
No. I mean, yes, but...
So you're stuck with parsing you're stuck with parsing the words of the statute. You're also stuck with parsing the words of the rule.
I think with respect to the rule, you have case law to aid you. With respect to the interpretation of the statute, you don't. With respect to the interpretation of the rule, you have O'Keefe, which talks about deliberate, tactical choices, conscious choices not to name a party. You have Timon, what looks to Black's Law Dictionary and to Webster's Collegiate Dictionary to define mistake. And there it's the absence of this deliberate act. And what I would ask you to focus on proper party.
But you didn't sue the county initially because you did not believe that you had to. Is that a correct statement? At the time that you filed suit against DOR, you decided that because the tax isn't due yet, we don't need to sue the county. Is that correct?
That is not correct.
Okay.
That was an argument that we made at the court below to try to save ourselves. But I don't think that was the mental. No, but that's not the mental thought that goes into the lawyer when he's filing this thing. I mean, it's clear from Mr. Santos's affidavit that he did not know that the county needed to be named, and had he been told, as 12b-7 required, that he would have immediately added them.
Is it? Let me make sure I understood something I thought I heard you say earlier, which is you said you look at it from the perspective of the party to be added.
Correct.
So if I understood your argument correctly, and just tell me if I'm wrong, tell me why I'm wrong. Your argument was, well, if you can impute notice and can impute knowledge, the county imputedly knows, that it should have been named because the statute requires it to be named.
Absolutely.
And therefore, there is a, quote, mistake sufficient for the statute because the county, from the county's perspective, it's sitting there saying, well, I knew I should have been added.
Exactly.
That's your argument?
That's exactly right. And remember, the touchstone of 15C is, I mean, we're talking about this in context of relation back, statute of limitations. I mean, here we have a 60-day statute of limitations. You add the 120. This isn't a stale claim. And the reason unity of interest and identity of interest apply is because you have the entity involved in the evaluations. The only entity involved in the valuation, the county, is on notice. I mean, not the county, DOR, They're participating in the case. They know. They know, and they say in their brief, we knew when we read the prayer for relief that you had made a mistake. And look at the attorney's conduct.
Well, so Rule 15C doesn't really apply then, because in all tax cases, the county knows they should be sued.
And for purposes of Rule 15C, I think it's a fact-intensive inquiry. And here, and I mean, Ellman and Pargman both talk about it. It's a fact inquiry. And you look at the facts of this case and what counsel's conduct was. Counsel clearly thought it was a 15C mistake.
Well, again,
And he waited until the day 15C ran.
It's not that they're not the party to be added. It's what the state knew or didn't know doesn't only goes to this idea of estoppel. To me, but what I understand you're arguing is this isn't your typical 15C motion. To me, the typical 15C motion is I sued Joe Blow in a car accident. I thought he was the manufacturer of the car. I sued Ford. I assumed they were the manufacturer of the car. Turns out that it was manufactured by someone else, or it was a component of the car. So now I want to go back and add in the Goodyear, because Goodyear manufactured the tire. That's usually where the mistake of fact comes in, and whether it can relate back or not. Because in discovery you find out, gee, the tire may have been defective. What you're arguing here, if I understand it, is that's not the same situation as this, because the statute says the county has to be added. And since the state knew, and there's a unity of interest, state's knowledge and the state's notice to the state is imputed to the county, and the county knew it had to be added. Is that right?
That's exactly right.
Okay.
And if I can add one closing thought, I would submit that that is consistent with the purpose of the rule. I mean, if you look at the history of 15C, the Social Security cases, the fact that 15C was originally adopted to address these issues where there are problems in Navy and government, in all of those cases, I would submit that there is a statute which directs who to sue. If there's a statute that directs who to sue and you don't follow that statute, that's a mistake of law. I mean, this broad label of mistake of law does not appear in the language of 15C. It is a creation of O'Keefe, but that mistake of law in O'Keefe talks about deliberate tactical choices. Counsel for Sun Devil did not have a choice. And if it didn't have a choice, then there is absolutely a proper party, and that proper party knew.
Thank you.
Thank you.
Why don't you add, put it at 2 minutes with rebuttal time.
Thank you, Your Honor.
And I would like to ask you about the 15C. Why is that not a mistake in identity? It's clear under the statute so that the proper identity of the parties to be named, the state and the county, they mistakenly only identified the state. So it seems to me that is a mistake in the identity of one of the necessary parties. It's a mistake in not naming both necessary parties.
It's a legal mistake in not naming both parties which are required to be named under 42-16-208, which states that in the event of evaluation by the department, the plaintiff appellant is required to name both the Department of Revenue and the entity, in essence, which collects the tax. And in this particular circumstance, in the valuation of electric generation facility, the taxes are collected by the county where the property is located. So,
if ever there's a situation where we would want to focus on prejudice, it would be in this type of situation where the county has virtually no input into the determination regarding the legal issue that's being addressed. They're simply required under the statute to be named. Absent that statute, they presumably could have gone forward and then could have gone forward separately against the county.
well, they could have done that but for the statute of limitations and but for the fact that they could have gone forward against the Department of Revenue interminably and ended up with a judgment that was uncollectible for having failed to name the party that had the refund fisc, which was the county, not the state. I think that it would be fair to assume, Your Honor, that in every instance of central valuation where the department is defended by the AG's office on the valuation, there isn't anything necessarily for the county to do in terms of that valuation defense. Notwithstanding that, there's a very distinct statutory requirement that the county be named. And
Unity of interest is completely satisfied here. You would agree with that?
I don't believe that there is a unity of interest. I don't believe that that unity of interest exists. Well, I don't think that
the legal issue being addressed, and the county doesn't have any separate argument as to what the seller's cost should be.
I don't think that they would have any argument nor input into
There's
that.
no question about unity of interest.
Well, but for having to pay at the end of the day.
Yeah, Council, you brought up that there be a problem with the statute of the limitations. It seems like the state had a hand in that because of when you raised this issue, it was too late for Sun Devil to go ahead and amend its complaint?
Your Honor, I would say in response to that it's not our obligation to necessarily tutor counsel for appellants on what the law is. They're presumed to know the law. I would also go on to say that...
So you can wait until you can wait to raise the issue until it's too late for the other party to fix the problem?
In essence, I could have waited probably until the case had been fully litigated before this court, and then they would have found that there were no judgment that could be satisfied by virtue of statute. That would be a far worse circumstance than the timing under which the issue was raised.
So your argument is you never had to file a motion to dismiss. You could have just waited to appeal and suddenly say, too bad. You're not going to be able to. Good luck on collecting.
This would not. I wouldn't necessarily take that approach, Your Honor. Perhaps it would be more appropriate to wait to the conclusion of the case at the tax court. But
and you never raised lack of. Did you raise lack of indispensable party in your answer?
I can't say for sure, Your Honor, as I sit here today.
That would be a waiver, right? If you didn't.
I cannot say. I'm not fully prepared to address that question, Your Honor. I would like to close with a few remarks regarding the statutory construction, if I may.
We'll give you 1 minute.
Well, basically, I still stand firmly on the ground where a statute lays out a series of definitions that define what cost is, and then says that they must have the cost information in order to carry forward the seller's cost information, that they must have the cost information, and merely having some kind of assessment of cost, the book cost information that came down as a result of the bankruptcy determination of what the book cost of it is, does not satisfy that. That the Gila River cost information, that's a book cost figure. It's not a sales transaction figure. It is an opinion of value. And basically...
You're not saying it's an arm's length acquisition?
The bankruptcy court called it an arm's length transaction, and I'm not going to quibble with that. But be that as it may, I think that the truest arm's length transaction is the one that took place and which resulted in $186 million of cost above what had transpired in the bankruptcy court when Sun Devil purchased the facility from Gila River. I see nothing wrong at all with the Department of Revenue valuing property based upon a market that is reflective of a subject sale. And I think that that's very much what the statute does. It says if you don't have the cost information, then it is your cost in an arm's length transaction, and that is whether it is higher or lower than the preceding cost.
Okay.
Can I ask one question?
Sure.
Thanks.
Sorry.
In your opening brief at 18, you do say that the cost, the first use of the word cost, in D1 is the seller's cost. Is that, you're saying that's a mistake? And I went back and looked at opening brief page.
I would say that's a
You did
mistake.
say that.
I would say that's a mistake, Your Honor.
Thank you all for your argument today. We'll take this matter under advisement and issue a decision in due course. And with that, we'll stand at recess.